Hello guys, today we are going to talk about nuisance and the law of tort.
Hello, my dear students. This is Sandeep.
The word nuisance is derived from the French word nuire, which means hurt. And it is an unlawful interference with a person's use or enjoyment of land. This legal right cannot be taken away without lawful justification. Contrary to the given protection, if someone unlawfully interferes with his entitlement of a person, she commits nuisance under law of torts. Generally, a person is entitled to the full and reasonable enjoyment and use of his property, tangible, intangible, movable, or immovable. Jurist Salmond expressed the wrong of nuisance consists in causing or allowing without lawful justification the escape of any deleterious things from his land or from elsewhere into land in possessions of the plaintiff. Water, fumes, smoke, gas, noise, heat, vibration, electricity, germs, animal, etc.
Jurist Samo says. So,
Essential element of nuisance under law of torts. For making an act of nuisance actionable under the law of tort, the following essential must be satisfied: wrongful act by the defendant, damage, loss, inconvenience caused to the plaintiff. Private nuisance. There are two kind of nuisance: private nuisance and public nuisance. Now we're talking about private nuisance. Private nuisance influence an individual rather than the world at large. It provides the affected person a claim of right in personam. Private nuisance occurs when the action of the defendant affects only the plaintiff in his own enjoyment of land and property and no one else. Technically, when a person does an action which influence action another person and intercept the latter from performing right over his own property, it does not affect any other person. The plaintiff can claim for unliquidated damages and considering the seriousness of injury. The same are decided and awarded to him.
so nuisance can be two types.
Essential of private nuisance: unlawful or unreasonable interference. Such interference causes a legal injury to the plaintiff only. The injury may be in respect of either property or physically discomfort to the plaintiff. A public nuisance. Now we are talking about public nuisance. Public nuisance is defined as an unreasonable and unlawful act of the defendant that causes substance inconvenience and legal injury to the people at large. It comes into play when by the act of the defendant a mass of people is influenced negatively. In the words of Birmingham public nuisance, when the defendant action materially affect the reason, comfort, the convenience of life of a class of Her Majesty's subject. Public nuisance, being a crime under the Indian as well as English law, finds its recognition in various statutes of the country. Thus, any action which seriously hinders with the health, safety, comfort, and convenience of the public in general, or which intend to demean morals, come under public nuisance. Example of nuisance. There are many examples of nuisance we can see around us. Some of the example are fully or partially blocking a highway. Sometimes we see people block the highway for their satisfaction. That's a kind of nuisance. You can shoot a file for this. Picketing on road, blocking a canal, making obscene telephone calls to large number of women, premises near to highway in danger state, parking coaches on public highway, golf course too close to public road. I hope you understand the nuisance concept of nuisance clearly. Thank you for watching this.